Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a book from the Law Society, now called Law Society Publishing. This book here, it's called Resolution Family Disputes Handbook. General editor is Andrew Greensmith, and it's the Legal Handbook series from the Law Society. There's some blurb on the back, and as you come to expect with the Law Society, standard structure forward there, and then you've got standard chapters with paragraph numbers. Then right at the back you've got some appendices, and then you've got a useful index which gives you quite a lot of information in one easy volume. There's a review written on Flickr by Elizabeth, my wife, and I, and we've given it the title in a more detailed review, Resolving Family Disputes Without Going to Court, the Evolution and Utility of ADR. And as we all know, ADR is very much favoured at the moment, and rightly too, by the senior courts, and it is the first step in any dispute proceedings. Practitioners therefore involved in advising clients disputing divorce cases and other family matters would, in our view, do well to acquire this handbook, which provides a definitive guide to best practice in this sensitive and contentious area of law. It's very difficult with the emotions flying a lot in this sort of type of practice. As one of the latest of the estimable library of useful volumes published by the Law Society and Law Society Publishing, the handbook is an important contribution to the growing body of literature on alternative dispute resolution, ADR, which we're all familiar with, and we're well aware of what people, the senior parts of the legal profession, think of it. The evolution, therefore, of ADR over the past 30 or so years has been noteworthy because it offers the possibility and the option of an alternative method of resolving ostensibly intractable disputes, other than that of going to court, which is widely regarded by mediators as a last resort. Under the editorship of Andrew Greensmith, this useful book from Law Society Publishing brings together the work and research of a team of no less than 16 experts in this field, most of whom are accredited members of Resolution, the mediation organisation ably described by contributor James Pirrie in the chapter on principles and values. As the editor, Greensmith, observes, ADR continues to emerge as a credible and sensible alternative to litigation in family proceedings, and examines the now more sophisticated, fine-tuned concepts and procedures now emanating from ADR, from early neutral evaluation and private judging to directive mediation and collaborative law, all with the aim, of course, of avoiding confrontational court cases where, as I've indicated earlier, the emotions flow and you don't get the sort of satisfaction you might be able to get in this alternative way of doing things. It's produced in association, as I've said, with Resolution. The handbook therefore provides an outline of the available alternative models and processes in all their aspects, including assembling the dispute resolution team, as well as the collaborative process, funding, disclosure and closure. In other words, both in the emotional sense and in the legal sense of negotiations having broken down. There are useful tables of cases, as I've shown, and legislation, and plus 5 appendices, one of which, in keeping with the book's eminently practical approach, offers top 10 tips for mediators and collaborative practitioners, all of which makes for fascinating reading, especially if you are professionally involved in this difficult area of family law, in which case you'll find the advice and comment in the handbook absolutely indispensable in the conduct of your practice. And as I've said, you can see the various ways in which it's done. Further reading is very helpful, but the one thing that is important is Appendix 1, the top tips. So thank you to Mr. Greensmith and Law Society Publishing and the team for an excellent work. Thank you. Bye-bye.